Hi guys, D Aluwalia again. Now guys, today I want to talk about a very important topic in Australian immigration law. Now the topic is Section 48 bar. Now what Section 48 bar is? Basically guys, if someone is in Australia and your visa is refused or cancelled, and if you do not have a substantive visa. So what I mean by that is, so hypothetically, I am on a tourist visa and then my visa expires on 10th of April. Okay, now I applied my application on 8th of April. So the moment I will apply my application, originally I will get a bridging visa. Now that bridging visa will get activated on the midnight of 10th of April. And once the bridging visa will be activated, and of course, my tourist visa has run out. So now I am on my bridging visa, and during that period of time, if my visa is refused, I would be Section 48 bar. Or if someone has a visa and your visa has been cancelled for any reason, then also a Section 48 bar would apply if you are in Australia. So let's talk about this guys today. What Section 48? So now let's go to. So let's talk. These are the few topics what we're gonna talk about today, guys. Visa refusal and cancellation. I've told you a little bit about it, purpose and the regulation objectives. Visa exempt from Section 48 bar. So basically what visas are exempt from Section 48 bar: partner and family viability, skilled visas, eligibility, applying from overseas strategies, and key takeaways and guide for this guys. Alright, okay, so let's go to the next section. Now guys, understanding Section 48 bar. Section 48 of Australia's Migration Act impacts those whose visas are refused and cancelled. It restricts new visa applications if you are left without a substantial visa in Australia. This is what just I said to you before on the first page of the slide, and its implications in crucial for those navigating visa processes after a setback. Okay guys, so let's talk about more about it. Okay, now guys, visa refusal and cancellation, reason for the bar. Section 48 bar aims to prevent successive visa applications to delay exit from Australia. So the purpose of this bar initially was, guys, so people whose visas are refused, technically, so they leave Australia and they don't stay here and try to apply more and more visas or repeating visas. So that's the whole purpose why this particular section was set out. All right, guys. Now let's talk about regulatory objects. The Section 48 aims to maintain integrity in the migration system, as just what I said to you, and basically, blocking repeat applications, as I said to you earlier. It's designed to maintain integrity by preventing individuals from exploiting procedural delays, blah blah blah. All right, this is I already discussed, so I'll move forward, guys, because I don't want to make the video so long. I want to try to keep it within 10 minutes. Okay. No direct waivers, waiver limitations. Now, there are no waivers in Section 48 which regulates leaving Australia for non-exempt visa application. If on subscription visa, Section 48 does not apply, which ensures clarity in visa laws and prevents attempts to cumulative the system. Okay. Now, guys, types of exempt visas. Now, generally speaking, partner visa, protection visa, semi-humanitarian visa, and there are certain skilled visas which are exempt from Section 48 bar. So we're going to talk about this because I know this is very, very critical, and this is something important for those who are here in Australia. Their visas have got refused or cancelled, and your matters are in tribunals or in different courts, and now you're still looking to apply a valid application in Australia, which may able to help you to settle down in Australia or whatever purpose you got for it. Okay, now you're going to meet specific eligibility conditions. So let me give you an example. So let's go step by step. Now guys, you can always apply partner of visas if you are Section 48 bar. Now guys, you got to understand one more thing. when you are applying for a partner visa while you are on section 48 bar, you need to meet a schedule 3 requirement. Now let me, okay, so basically if you are in that situation, it's always a good idea, you can contact us or you can contact immigration agents or lawyers who can basically make you understand what that means. Now I'll give you an example. So I'll give you a simple example. I have a client. Now he was basically, his visa was refused and he had a section 48 bar. Now he also have to had an Australian partner, so they got married and we lodged a partner visa. Now the whole during this whole process period of time, it was 2.5 years, but what happened was they planned to have a baby. Until the time before we can get the decision on the application of the partner visa, they already have an Australian baby because one of the partner was Australian in the application, and we were able to get, he was able to meet schedule 3 requirement. So just giving you one example, there could be many other examples as well, just to make you understand what a schedule 3 requirement is. Now of course, if you're applying for a protection visa, your humanitarian visa, so giving you an example, let's put it this way, you are here from Lebanon, and of course there's been war in Lebanon, and things are not, things are changed from the time you come up and you are eligible to apply for a protection visa. You'll be able to apply for the protection visa, and section 48 bar would not apply on you. Now there are also some skill visas, guys, which is subclass 190, 491 and 494. Now guys, this waiver was being introduced during the COVID time, when migrants could not go back to their home country to lodge their application. Because guys, in many circumstances, which we're going to talk in our next slide or following slides, where I will explain you, if you have a bridging visa A, how you can get a bridging visa B, and you can go overseas as well. Okay, now to focus on skill visas exempt from section 48 bar, examining the specific visa subclass, state nomination rules and application procedure. So yes, you have to meet all of the requirements, that's for sure, but yes, you can be, if you are on section 48 bar. So again, as I told you guys, subclass 190, that's one visa you can apply for, 491 you can apply for, and 494, which is basically employer sponsor visa. So if you have an employer in a regional area, which is basically anywhere other than Sydney, Melbourne or Brisbane, and you have 3 years of work experience and you have a skill assessment positive, you can apply for this visa. And even if your visa is cancelled and refused and you have a section 48 bar. Okay, now let's go to the next slide, guys. I have already spoken, I don't want to take much time and speak about this. You guys can go through these slides later on as well. Okay, now this is basically talking more deep about the basic visas and step of orders. Now also guys, as I said earlier to you, for example, this is another way to deal with section 48 bar. So you applied for your student visa or an extension of student visa in Australia, and then your student visa got refused. Your application is in tribunal with A18 now, and you have a bridging visa A. So guys, you can get a bridging visa B, you can travel overseas. When you go overseas, you can lodge your application, because section 48 bar only applies when you are in Australia. You go overseas, you lodge your application and you can come back. So that's another way of dealing it, guys. Okay, now again, I think I've already explained about it. It is crucial to understand applying for offshore bridging visa first. I think I've already explained about it. So that's pretty much, guys, what it is, and that's the end of the slide. Now again, guys, if you need any help, you can always contact my office. Dear Walia, take care. Bye for now.